Today we will be looking at the area of US constitutional law. When talking of constitutional law in the United States, it is necessary to speak both of state constitutional law, as each of the 50 states has its own constitution, and of federal constitutional law arising out of the federal constitution adopted in 1787. It is proposed to dedicate this discussion to US federal constitutional law and the US Supreme Court. Pursuant to Article 3 of the Constitution, the Supreme Court is empowered to rule on all cases and controversies arising under the Constitution. It is this power to interpret the sometimes vague and general provisions of the Constitution that has allowed the Supreme Court, through its decisions, to define the nature and character of the United States today. In so doing, it has become one of the most powerful courts in the world. Much of the Supreme Court's power results from its power of judicial review, whereby it can review acts of the other branches of the federal and state governments to ensure that they respect the provisions of the federal Constitution. If they do not, the Supreme Court can declare their actions to be unconstitutional and thus illegal. Nowhere does the US Constitution expressly provide for the US federal courts to have the power of judicial review. Rather, this power was implied to exist by the Supreme Court itself. The Supreme Court came to this conclusion by virtue of its interpretation of the Constitution, namely the Article 6 Supremacy Clause and the Cases and Controversies Clause contained in Article 3. The Supreme Court considers that if federal law is supreme under Article 6 of the Constitution, and if Article 3 gives the Supreme Court the right to apply federal law, then the court has the right to ensure that acts of both the federal and state branches of power come within the provisions of federal law, as established by the Constitution. The power of judicial review is extremely important, given that the Supreme Court's interpretation of the Constitution is binding on the legislative and executive and lower judicial branches of the federal government and the legislative, executive, and judicial branches of the state governments. Consequently, in the United States, it is the Supreme Court and not the legislative power that ultimately decides on the legality of issues such as the death penalty, euthanasia, or abortion, insofar as the Supreme Court rules on the constitutionality of the laws adopted in these areas. The Supreme Court's power of judicial review as regards controlling the legality of the acts of the federal branches of government was established in the case of Marbury and Madison. In the later decision of Fletcher and Peck, the Supreme Court ruled that it also had the power to review the constitutionality of the acts of the state branches of government. However, the Supreme Court tends to use its power frugally and will, for example, only rule on the constitutionality of a law if the case cannot be resolved in any other way. Indeed, the Court has developed a number of rules to allow it to avoid ruling on such issues unless it is truly necessary. The first rule that the Supreme Court has developed in order to avoid ruling on the constitutionality of issues is the ripeness doctrine. Pursuant to the ripeness doctrine, the Supreme Court will not decide on an issue in advance, i.e., it will not rule on the matter in advance of or prior to the problem actually materializing. Consequently, even if a law adopted by Congress is clearly unconstitutional, the Supreme Court will not rule on the issue of its constitutionality until it has actually been applied in an unconstitutional way. It is said that the Supreme Court will not anticipate a problem. The second restriction that the Supreme Court has imposed arises out of its interpretation of the Cases and Controversies Clause. As we have seen, Article 3 of the Constitution empowers the federal courts to hear cases and controversies arising under the Constitution. Thus, in order to be able to bring a case before the Supreme Court, the case must be based on a specific problem arising under the Constitution, and there must be the possibility of redress, i.e., the possibility of a solution. Spurious claims will not be heard by the court. Another aspect of the Cases and Controversies Clause is known as the standing or locus standi requirement. Under this principle, people wishing to bring an action before the courts must show that they have personally suffered the injury that is the subject of the action being brought before the court. Consequently, one cannot bring an action if it is founded on injuries suffered by others. For example, if the rights of another are being infringed, one cannot bring the action on their behalf unless that person is their guardian. It is necessary that the injured party bring the action in their own name. The third rule is the mootness doctrine. An issue will be considered moot and thus not to be capable of being the subject of a legal action before the Supreme Court if the judgment of the case will have no effect on the resolution of the problem. For example, an attempt to prosecute someone for a crime if that person is already dead. The final rule concerns political questions. If the question before the Supreme Court is fundamentally a political issue rather than a legal one, the court will consider that it is prohibited from hearing the affair. In this regard, the court has shown an unwillingness to get involved in issues that are primarily political rather than legal. However, even if the matter is primarily political, where the underlying question is fundamentally a legal one, the court will not hesitate to rule on the affair, even though such a ruling may have an important political consequence. For example, the Supreme Court's decision on the legitimacy of the Florida state vote during the 2000 presidential election. In this case, the decision of the court effectively handed the presidential victory to George Bush Jr. In making a summary of these rules, it could be said that the ripeness doctrine requires that the problem actually exists. It is not enough to show that the problem is going to exist. We could say that the Cases and Controversies Clause and standing requirement necessitate that the matter be a real issue presenting a problem under the Constitution, and that the plaintiff have personally suffered the injury that is the subject of the action, and that the mootness doctrine requirement requires that the problem on which the action is based continue to exist and continue to be relevant at the moment the action is being brought. Much of the Supreme Court's power derives from the willingness of some of its judges to interpret the Constitution in a dynamic way. This is referred to as the instrumentalist approach to constitutional interpretation. Instrumentalist judges consider the Constitution to be a living, changeable document that should be interpreted to reflect changes in society. Instrumentalism allows judges to interpret the Constitution broadly, going beyond its literal meaning. Supreme Court justices are assisted in this approach by the fact that the US Constitution is drafted in a very general way. For example, the Constitution prohibits cruel and unusual punishment. This notion is clearly very vague. It is then the work of the Supreme Court to decide whether forms of punishment, such as the death penalty, can be considered to amount to cruel and unusual punishment. Ultimately, this is a subjective evaluation. Indeed, it could be said that the court develops new laws deriving not from what the Constitution actually states, but from what the judge considers it to state. in the context of either the judge's values or what the judge supposes to be the values in society. For example, although the application of the death penalty in cases of robbery might not have been considered excessively cruel and unusual punishment in 1791, it is probable that it would be considered an extreme form of punishment today. Thus, the judges that interpret the terms of the Constitution actually define the scope of the Constitution, and some judges do this more broadly than others. This willingness to effectively create law by interpreting the Constitution in a dynamic way is sometimes referred to as judicial activism. There are, however, other Supreme Court justices who do not share the view of the instrumentalists, and they consider the Constitution to be a fixed document that should be interpreted literally, not taking changes in society into account. These justices are called originalists, and the originalist approach to interpreting the Constitution is popular amongst more conservative judges. Many judges come somewhere between these two extremes. In interpreting the sometimes vague terms of the US Constitution, the Supreme Court has in many ways become the referee of American society. For example, in the famous case of Roe and Wade, the Supreme Court recognized the legality of state abortion laws, effectively legalizing abortion in the United States. In other countries, this is a decision that would have been taken by the legislative power. Indeed, the influence of the US Supreme Court cannot be underestimated, and in many ways, the court plays a role similar to that of the guardians in Plato's ideal republic. However, despite its wide powers, important political power is also vested in the legislative and executive branches of US federal government, and also in the state governments, ensuring that the United States continues to enjoy a balanced and equitable separation of powers. We hope you enjoyed this introduction to constitutional law and the Supreme Court in the United States.